Because he has a contagious, whatever, and on scalp.
So he stay outside, is he outside?
He's outside.
Okay, just have him stay outside.
You know, I'll get him some of the people.
Yeah, okay. Where's my?
You want to get you in?
Yeah. Okay, big one. Yeah.
All rise. County Court 11 2 in session, Judge Terrence on presiding.
You may be seated. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your most serious type of criminal offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, felony cases are divided into 5 categories. We'll start at the top, work our way down to the bottom. You have a capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. Now, if a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type of punishments because, as I mentioned to you earlier, your case is a misdemeanor case. Now, misdemeanors are divided into 3 categories. Again, we'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanors are cases that start in the JP court or the city court. And they only come to this court when a person is found guilty in one of those courts, the JP or the city court, and they appeal the case. Once they appeal the case, they get a whole new trial. And it comes to this court. Now, the range of punishment, same. The range of punishment for a Class C misdemeanor is a fine only. You cannot be given jail time. The fine cannot exceed $500. Okay, so you have a Class C misdemeanor, the fine cannot exceed $500. Now, if you fail to pay the fine, or if the fine was converted to community service and you fail to perform the community service, then the court can issue what is called a habeas pro fine. I'll explain that to you. Habeas pro fine is basically a warrant for your arrest to pay the fine or sit the fine out in jail. Now, if you sit the fine out in jail, you will be credited at $100 per day that will go toward the fine and court costs. So every one day that you stay in jail, $100 will be credited toward paying off the fine and court costs. Now, just for a little example of a Class C misdemeanor, it could be not having your seatbelt on, speeding, having an expired license sticker. Those are examples of Class C misdemeanors. Now, the next highest misdemeanor is a Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or you could be given a fine that does not exceed $2,000, or you could be given both jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor. With the Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days in the county jail, or a fine that does not exceed $4,000, or you could be given both such jail time and a fine. Now, you may qualify for probation. There are two types of probation that a person can get. One type of probation is called unadjudicated probation. Unadjudicated probation, we normally refer to as deferred probation. And the reason why is because with the unadjudicated probation, you do not have a conviction on your record. It's deferred. And if you successfully complete that probation, the case will be dismissed. It will not result in conviction in the record, and you may qualify for what is called a non-disclosure. Non-disclosure basically means that your record will be sealed to the general public and the case will be dismissed. Now, sealing, the operative word is general public, which means that there are certain governmental agencies listed in the Texas Code of Criminal Procedure that can't have access. But most of the public is the general public. So most of the public cannot have access if you get a non-disclosure. So for example, let's say you're trying to get a job with ExxonMobil. You have a non-disclosure. ExxonMobil do a criminal background check. If that's sealed, they can't see you. Okay? That's the general public. On the other hand, if the police department does a criminal background check, they can see it. Why? Because they're probably listed as one of the agencies that can have access to your criminal record in the Texas Code of Criminal Procedure. But most of the public is general public, so most of the public cannot have access to it. Okay. Now, the next type of probation is called adjudicated probation. We talked about unadjudicated probation. Now we're saying adjudicated probation. With adjudicated probation, it does result in a conviction on record. Now, we refer to adjudicated probation as regular probation. You will have a conviction on your record. However, there is something that is called judicial clemency, whereby the judge can set that conviction aside. Okay? You will no longer have a conviction. And you would not have this conviction on your record. However, in order to qualify for judicial clemency, three things has to happen. One, you have to successfully complete that probation. Two, there cannot be any more time left on the probation. And three, you have to be successfully discharged or let off the probation by the probation department. If those three things happen, then the court has the discretion to set that conviction aside, and you will no longer have that conviction on your record. Now, however, if you get another conviction later on, we call it a subsequent conviction. If you get a subsequent conviction or conviction later on, then the case that you receive judicial clemency on can be resurrected, revived, brought back up, and used against you. And if you try to get a license with Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke or suspend your license. Okay, now, as a defendant in a criminal case, you have rights. One of the rights that you have is a right to have an attorney. I'm getting ready to go over your right to have an attorney. On the clipboard that you have before you, there should be the first document should be behind the short page. The first document should be judge's explanation of rights to defendants without attorney. Okay? That document states that as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number 3, you may represent yourself. Those are your 3 options. Now, the first sentence below number 3 states that if you want an attorney, you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date from today's date to give you time to hire an attorney. The second paragraph, the second one-sentence paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire. Now, the financial questionnaire is a 3-page document that is also on the clipboard. It is titled Affidavit of Injuries or Jefferson County Affidavit of Injuries. You have to fill out the first page of that document, and then if you turn to the second page, if it's in correct order, if you turn to the second page of that document, there should be something at the top. That's the first page. Okay. I'm glad you showed it to me. Okay, good. Yes. The second page, it should state defendant's oath at the top. You'd have to fill out that portion. And then in the middle portion, it should say unsworn declaration by defendant. You would have to fill out that portion and then you'll stop. Okay? Now let's go back to the judge's explanation, that first document. Okay. The first document, the third paragraph states that you may not talk to a prosecutor unless you first sign a written waiver. Now, what that paragraph is for is for individuals who like to waive their right to an attorney. They like to represent themselves. If they represent themselves, that means that they are their own attorney. Okay? And so just like an attorney can talk to the prosecutors about the case, the prosecutors are the 2 district attorneys, assistant district attorneys that sit here. Just like your attorney can go over and talk to them, because you represent yourself, you can talk to them about your case. Okay? So that paragraph is saying that you may not talk to the prosecutors if you want to represent yourself unless you first sign a waiver of your right to be represented by attorney. Now, the waiver, this is only for individuals who will be representing themselves. That waiver is a 1-page document. Yes. It's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. That's only for individuals who would like to represent themselves. If you are not representing yourself, you don't have to worry about that document. Okay? And so you have to read and sign that document. All right. Now let's go back to that first page, judge's explanation. You'll see a paragraph in block form. It's the second to the last paragraph. It's in block form. That's for individuals who will be representing themselves. That paragraph states that be aware there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, the last 1-sentence paragraph It's for individuals who like to represent themselves. It states that if you represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Let me give you an example. Let's say you represent yourself, okay? And let's say you want to talk to the prosecutors to see if they can give you probation, or deferred adjudicated probation, or unadjudicated probation. And so you talk to the prosecutor, and the prosecutor say, "Well, I'm offering jail time." And you say, "Well, I don't want jail time. Well, Judge, I changed my mind. I don't want to represent myself. I want a lawyer." You can do that, okay? That's just an example of what that paragraph means, that you can change your mind at any time and request that an attorney be appointed to represent you. Okay, now at the bottom of that document, you will see 5 lines to the left. Now, everyone here is going to put their initials on one of those lines. Okay, if you would like to hire your own attorney, then you will place your initials on the first line to the left. If you like to, everyone who would like to hire their own attorney, place your initials on the first line to the left, sign the bottom of that document, and today's date, December 2nd, 2025. All right. If you have already hired an attorney, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. Then you'll sign the bottom of that document, date it, and stop. And that's the only document you would have to sign. For individuals who will be hiring an attorney, or if you've already hired an attorney, that's the only document you have to sign. You don't have to worry about nothing else. All right. Now, if you would like to apply for a court-appointed attorney, then you will place your initials on the third line to the left, sign and date it, and then you will fill out the affidavit of indigence, that 3-page form that we talked about. You're gonna fill out the first page, and then on the second page, you're gonna fill out the top portion that says defendant's oath, and the middle portion that is titled unsworn declaration by defendant, and then you'll stop. Now, if you would like to, well, if you've already been appointed a court-appointed attorney, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right, and then you'll stop after you sign and date. Now, the last line, that's for individuals who would like to represent themselves. You'll place your initials on the last line, the fifth line, because it states that you would like to waive your right to the attorney and represent yourself. Then you'll sign and date it, and then you'll sign the form that is titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. You'll read and sign that document, and then you'll stop. Okay. Do we have any questions? Anybody have any questions? All right. Now, what we're going to do now, we're going to give you time to fill out the paperwork. Okay. So you don't have to fill it out right now. I just need to explain to you some more rights that you have. The next right I want to talk about is your right to have a trial by jury. In that area over there, 12 boxes, where Mr. Stewart is sitting, we call that the jury box. 6 citizens, because we in misdemeanor court, we only have 6 of the jury. District court, we have 12. But in misdemeanor court, we have 6. And so 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence that's presented by the state and by the defense. They will listen to the arguments of the state and the defense, and then they will go into the jury room to deliberate, and they can decide to find you not guilty or guilty. Now, you can waive your right to have a trial by jury. What that means is you can give up your right to have a trial by jury. Okay? Now, you still can have a trial, but it's not a trial by jury. It's a trial by judge. We call it a bench trial. Why? Because the judge sits on the bench, and so they call it a bench trial. Now, the judge will listen to the evidence that's presented by the state and by the defense. The judge will listen to the arguments of the state and the defense. the judge will apply the facts of the law and decide to find you not guilty or guilty. You can waive or give your right to have a trial by a judge as well, a bench trial. And if you do so, obviously, you enter a plea of either guilty or no contest. Now, there are three types of pleas that you can enter. A person can enter a plea of not guilty. What that means is you're telling the court that you did not commit the offense that you've been charged with. Or you can enter a plea of guilty. What that means is you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of no contest. And what that means is you will not be fighting or you will not be contesting the charges. Okay? And so if a person enter a plea of guilty or no contest, then they're obviously pleading to the charge. And so if they enter a plea of guilty or no contest, then they can enter into what is called a plea bargain with the state. A plea bargain is an agreement to settle your case. And if you have an attorney, your attorney will talk to the prosecutor. If you represent yourself, you'll talk to the prosecutors. They'll make an offer to settle the case. You can accept it or reject it. Now, if you accept the offer, then y'all have an agreement. Okay, we call that an agreed plea bargain. And with the agreed plea bargain, it comes before the judge. The judge can do one of two things. The judge can accept or reject the agreement. Now, if the judge rejects your agreement, you can tell the judge, well, judge, since you're not accepting my agreement, I withdraw or I take back my plea of guilty no contest. You can do that. Now, if the judge does follow the agreement, and that is go along with the agreement, and say within 30 days, because you have 30 days to file a motion for new trial or an appeal, you decide that you like to appeal your case. If you do that, you have to get permission from the judge that follows the plea bargain. And if the judge gives you permission to appeal your case, then your case is going to leave this court. No, it will no longer be here. It will go to another court and go upstairs to the Ninth Court of Appeals. There are 4 justices in that court. They will review your case to see, one, if you've been wrongfully convicted or whether or not this court committed an error by convicting you. They can do one of two things. They can grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, case over. Or they can send the case back down to this court or to this court to give you a whole new trial. If they deny your appeal, then guess what? You can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals located in Austin, Texas. Now, you would have to file what is called a pro se petition for discretionary review. I'll explain that to you. What that means, pro se means you represent yourself. You don't have a lawyer representing you pro se. You by yourself. Okay. And so you will be filing a petition. You'll be petitioning the Texas Court of Criminal Appeals to review your case. They can do one of two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty, case over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down here with orders. Okay? And or the next thing they can do, they can just simply deny your petition. If they deny your petition, then at that point, your conviction will stand. All right. Now, I said that you have a right to have an agreed plea bargain agreement if you work out an agreement with the state. You also, there's something that's called an unagreed plea bargain. What that means is this. You want to go forward with your plea of guilty or no contest. But you don't like the offer that the state is offering to settle the case. So you want the judge to decide what your punishment will be. We call that unagreed plea bargain agreement, okay? All right. Now, the other right that you have a right to have witnesses to come to court. If you want to try, you have a right to have witnesses to come to court. They sit in that chair where that microphone is. We call that the witness stand. They can do one of two things. They can testify for you or against you. If you're representing yourself, you can ask the question of a lawyer. Your lawyer can ask some question. We call that either direct examination or cross-examination. Now, You also have a right to waive or give up your right to have witnesses to come to court. What that means is you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in your case. Now, you also have something that is called, you have a Fifth Amendment right against self-incrimination. What that means is this: the Fifth Amendment of the United States Constitution gives us a right to remain silent. In essence, we don't have to testify in our case. The state, the government, the DA's office can't force you to take the witness stand if you invoke or exercise your Fifth Amendment right against self-incrimination. All right? Now, I know a lot of times we watch a lot of television shows like Law and Order, and we see the television lawyer go up to the witness stand and ask the witness a question, and the witness say, "I take the fifth." What he's saying is, I'm exercising my Fifth Amendment to the United States Constitution, and I'm not testifying. You can't make me say anything. You have a right to do that. And if you think about it, it makes sense. Why? Because the state of Texas has the burden of proof. What that means is they have to prove that you are guilty beyond a reasonable doubt. You don't have to prove yourself guilty. That's their job. Okay? That's their job. And so you can invoke your Fifth Amendment right against self-incrimination. All right. Now you can waive it, which means that if you waive it, you will be testified. All right. Now, the other right that I want to talk about that you have a right to have discovery. What that means, you have a right to see the evidence that the state has against you. Okay? You have a right to see witness statements, your statements, police reports, lab reports. You have a right to see video recordings, listen to audio recordings, right to see photos, right to see any documents, have access to any instruments that they have, whatever evidence that they have, you have a right to have access to that. We call that discovery. Now, you can waive or give up your right to have discovery, which means that you're saying that I don't want to have access. I don't want to see the evidence that the state has against me. That's you waiving or giving it up. All right. Now, everybody that's here for a case, you're here because one, charges been filed against you, you've been arrested, booked into jail, you're bonded out, you're either out on a cash bond, which means that you pay the full amount of the bond to get out of jail, or you're out on a surety bond, which means that you pay the bondsman a percentage of the bond to get out of jail, or you're out of jail on what is called a PR bond or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance. I say that to say this. Every day that you spent in jail, it can be used as credit toward your punishment. The operative word that I just used was every day. And I'll explain it to you. Let's say you booked into jail last night at 11:59 p.m. and you booked out of jail at 12:01 a.m. Right? That's 2 minutes. You get jail 2 minutes, but guess what? You get 2 days credit because it's 2 different days. Okay? And so every day that you spend in jail, you get credit for that time. So for example, if you spend 5 days in jail, the state is offering you 5 days to serve in jail. You won't have to serve no more time in jail because you'll be given credit for the time that you have served. We call it credit for time served. And so you would not have to serve anything. Now, if the state is offering 7 days, you serve 5, that means you only have to serve 2 because we will subtract 5 from the 7, and that leaves 2. Now, every day that you spend in jail also can be credited as $100 per day that will go toward your fine and court costs. So if you spend 5 days in jail, that's $500 that can be used toward your fine and court costs. So if the state is offering you fine and court costs of $500, you won't have to pay anything because the 5 days that you spent in jail has already paid it off. Therefore, it will be taxed and retired. Now, if the state is offering fine and court costs of $700, that means you would only have to pay $200. Why? Because you already have $500 credit. That will be subtracted from the $700, and that leaves 2. Now, you'll be required to pay it on the day that the case is disposed of. No problem. If you can't pay it on the day that the case is disposed of, that's not a problem. Why? We can put you on a payment plan. You can pay it off in small monthly installments. But let's say you can't pay it off in small monthly installments, even if we put you on a payment plan, no problem. Because we could convert your fine and court costs to community service, where you work at a nonprofit organization in Jefferson County. Now, you will be credited $12.50 for every hour of community service that you work. So in our scenario, where you owe $200, if you work 8 hours one day, that's $100. You work another 8 hours the next day or another day, that's 200, and then that's it. Your fine and court costs is paid off. Okay? And so those are the things that we can do. Now, Jefferson County has a program that's called pretrial diversion. For first time offenders, you haven't been charged with cases or any type of criminal offense before, they'll dismiss your case. And then you can get it wiped off your record. We call it expunged, like it never happened. Okay? Now, in order to qualify for pretrial diversion, it has to be first time getting cases filed against you, or case or cases filed against you. You have to have an attorney to help you with the application process. Now, the attorney could be a court-appointed attorney. It doesn't have to be somebody you have to hire. And it cannot be an offense for unlawfully carrying a weapon or resisting arrest. With all other offenses, you will qualify for pretrial diversion. And again, once you get in the program, they dismiss the case, you complete the program, you can get it wiped off your record. We call it an expunction. Wiped off, deleted, or erased from your record. Now, if you're a veteran of any one of the branches of the United States military, District Attorney's Office has another program that's called Veterans Court. With that program, the program is for veterans only. And if you was a veteran in any one of the branches of the United States military, what they would do, you get into the program, you complete the program, then dismiss the case. And then you can get a non-disclosure for participating in that program, where your record is sealed to the general public. Okay? This court, County Court at Law Number 2, has a program that is called the CSI program. What that means, it's an acronym that stands for Community Safety Initiative. It is a program that God led me to start within the first 100 days of taking office in March of 2017. With that program, the program is designed to address the issue of what we call recidivism. Recidivism just means that people commit crimes over and over. And so how do we stop it? Well, we stop it through the CSI program. With the CSI program, we have partnerships with local agencies. One of the agencies that we have a partnership with is Spindletop Center. It's our local mental health center in the Southeast Texas region. Now, what Spindletop has to offer, they have the expertise to deal with individuals who have mental health issues. Now, in order to participate in the program, you don't have to be insane. You don't have to be incompetent. You can just merely suffer from anxiety or depression or any other host of mental illnesses, and they have the expertise to address those issues. Now, what they will do, and we have some individuals from Spindletop here today, they're going to come out and talk to you a little bit more about the program. But what they will do, they will conduct a private interview for those who would like to participate. The interview could be in our jury room, it could be at their facility, it could be by telephone, whichever is convenient for you. Then they can do an assessment to determine what the mental health issue may be. And then they can develop a treatment plan to address your mental health issue. Now, if you are an individual who have problems with drugs or alcohol, then Spindletop has a program that is called ATAR. ATAR is just an acronym, ATAR, that stands for Addiction, Treatment, and Recovery. And we have a partnership with our local Drug and Alcohol Council that has a program that's called OSAR. OSAR is an acronym, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do will conduct the screening, do an assessment to determine what the issue may be with drugs, alcohol, or both. And they can develop a treatment plan for either outpatient or inpatient treatment. If you are unemployed, or if you're looking for a better job, well, we have a program that is called, well, we have a partnership actually with the Golden Triangle Empowerment Center. And the Golden Triangle Empowerment Center has a partnership with Lamar University, and Lamar University has a program that is called CICE. It's an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and placement program in the hotel industry, the shipping industry, the chemical industry. Once you are trained in any one of those areas that you select, they will help you to get a job in the area that you select. Okay? If you have not graduated from high school or you do not have a GED, they also have a GED program where you could get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we don't just give time. We take our time. And that simply means that we don't just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law Number 2 of Jefferson County, Texas, we don't just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs to get you started and living your best life, just simply let us know, because we can direct you to the individuals that you need to talk to, and fill out the brochures that you need to fill out to get you started. Now, as I mentioned to you earlier, we have some individuals from Spindletop. We have Caitlin and Deputy DeVille. They're going to come and tell you just a little bit more about the program that Spindletop has to offer.
Hello, good morning. I'm the Jefferson Sheriff's Office. I'm with Spindletop. And this is my partner, Caitlin. She's a qualified mental health professional. There's some pamphlets that the judge mentioned when I was told we got to fill out, and she can probably explain a little bit better than me, so I'm with them.
On the little paper that should be somewhere on your clipboard, it's like a little half sheet paper. That is not a court document. You do not have to fill it out. It is optional. You can leave it blank and still turn it in if you want to. We can always use the extra paper. If you have any mental health concerns like depression, anxiety, or PTSD, or if you have substance use concerns like any drugs or alcohol, then we can help you get in contact with the resources so you can have the support and the things that you need for that. We offer doctor's appointments, medications, counselors, therapy, and support groups if you're interested. If you have any questions, you can just write it down on your paper for me to talk to you because you have questions, and then I'll come and find you when the judge is done with you. Okay, any questions?
Okay, thank you, Deputy DeVille
Sure.
and Caitlin. Now, ladies and gentlemen, we have Mr. Johnny Stewart. He's from Family Services. He's going to talk to you about a program for individuals who have cases that involve family violence, like assault, family violence. He's going to talk to you about a program where it's part of the pretrial diversion program, where it's matters intervention and prevention program, where they would actually dismiss your case, and you can get that expunged from your record as well. Mr. Stewart?
Thank you, Judge. Good morning. I'm Johnny Stewart. I'm the BIP program director. BIP stands for Batteries Intervention and Prevention. They changed the name, used to be called the Domestic Violence Program. But we have one of the pretrial diversion programs that if you've been arrested first time for domestic violence, you have an opportunity to get this expunged from your record if you attend the program and leave the program successfully. We've been doing this for years and years, and very successful program. And you want to try to change behaviors. That's what we're here about. That's what judge was, talking about, not addressing the problem, not addressing the problem, addressing the problem. I love that saying, because what we do is try to change these behaviors, not only for you, but for your family. The family services have been around for a long time. We just opened up the brand new shelter, and it is for women and children. And if you, need some services there, or know someone who needs some services, for non-residential, we also, provide those services. But take advantage of this if you are here for a family violence charge. This is a good program, and it's gonna help you, and not only help you, but help your family also. But I appreciate this court, and I appreciate Judge, and I appreciate you guys as well.
Okay.
Thank you very much.
Thank you, Mr. Stewart.
Thank you, Judge.
All right,
Appreciate
now, you're welcome. Now, ladies and gentlemen, we're gonna give you time to fill out that paperwork. And then we're going to pick up the paperwork from you, and then once we pick up the paperwork, we're going to make sure that everything is filled out properly. We're gonna put you into one of three categories. One category is you wanna hire an attorney. Now, if you like to hire an attorney, your case will be reset to give you time to hire an attorney. The second category is for those individuals who would like to apply for a court-appointed attorney. And if you qualify for a court-appointed attorney, you will be appointed an attorney before you leave here. Okay? You'll be appointed attorney before you leave here today. And the third category is for individuals who like to represent themselves. They like to waive their right to attorney and represent yourself. Now, if you would like to represent yourself, you'll have an opportunity to talk to one of the prosecutors, and if y'all work out a plea bargain, your case will be taken care of today before you leave here, okay? Now, it's gonna take a little while. Now, if you need any help with filling out that paperwork, we have our court personnel, including myself, who will be happy to help you with filling out the paperwork. Now, it's gonna take us a little while to pick up the paperwork from you. So if you need to use the restroom, there are two restrooms right out here in the hall. We have the men's restroom in front of County Court at Law Number 3, which is right next door. And on the opposite side of the hall, we have the women's restroom in front of the 172nd District Court. Now, you'll be allowed to use the restroom. Come back in the court now. Please do not leave the courthouse. If you leave the courthouse and your name is called, and you're not here when your name is called, your bond will be forfeited. And if your bond is forfeited, a warrant will be issued for your arrest. And guess what? You will be arrested, and we're gonna have to go through this all over again. Okay? So we're gonna try to get you out of here as soon as possible. We're gonna put you in those categories. Again, if you need any help, just raise your hand and let us know, and then we'll have a court person that will come out to you, and then I'll call some up to me, and then we'll try to get through this as fast as possible. Let me tell you this here before I say anything else. Be mindful that we're still in court, so conduct yourself accordingly. All right? So at this time, the court will be in recess.
Make sure you complete your clipboard before you step outside, if you're gonna prolong your stuff in.
Oh, and something to write their name on that top line.
On the top where it says versus.
State of Texas versus. Print your name, no, because sometimes we
Can't read it.
we can't read your signature.
If you're done, or. If you're done, I can pick up your clipboard.
You come and stand in front of the bench.
Good morning, Your
Good morning. Mr. Wood, this is cause number 25 CCCR 2008. Case of style of the state of Texas versus Arlington Austin Wood. Mr. Wood, is that your full name?
The third, sir.
Okay. Mr. Wood, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
You may put your hand down. How are you doing, Mr. Wood?
Better.
Okay, I'm sure you've been worse too.
Yes.
Now, Mr. Wood, I have before me a document that is titled Judge's Explanation of Right to Defendants Without Attorney. Do you recognize this document?
Yes, Your Honor.
Is this your signature on the line that's titled defendant?
Yes, Your Honor.
And are these your initials on the line that state you have already hired Wright Kimberly?
Yes, Your Honor.
Now, before you sign and initial this document, did you read the document?
Yes,
Did you understand what you read?
yes,
And is everything in this document true and correct to the best of your knowledge?
yes.
Okay, Mr. Wood, your case will be reset to give Mr. Kimmel an opportunity to file his letter of representation. Our court coordinator is going to reset your case. Once you reset your case, you'll be free to go and you have a blessed day. Mr. Wood, could you please stand in front of the court? Are you ready?
Yes.
Please stand in front of the court coordinator. You have a blessed day.
And this is the box. See, the first one, right back up, let me add that. It's in the bottom.
Okay. Michael Wayne Esquita Jr. Did I pronounce your last name right? Escada. Escada. Okay. Mr. Escada, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Yes, Your Honor. Mr. Escada, you may put your hand down. How are you doing, Mr. Escada? Good. That's good. Now, Mr. Escada, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Yes, sir. And is this your signature on the line that's titled defendant? Yes, sir. And are these your initials on the line that state you like to hire your own attorney? Yes, sir. Now, Mr. Escada, before you signed and initialed this document, did you read the document? Yes, sir. Did you understand what you read? Yes, sir. Is everything in this document true and correct? Yes, sir. To the best of your knowledge? Okay, Mr. Escada, I read your answers. Your case will be reset to give you an opportunity to hire your own attorney. Our court coordinator is going to reset your case. Once she resets your case, you're free to go. And you have a blessed day and happy holiday to you. And happy holiday to you as well, Mr. Wood.
Yeah.
All right.
Anyone else?
Morgan Elizabeth Weatherly. Miss Weatherly, your full name is Morgan Elizabeth Weatherly.
Yes.
Ms. Weatherly, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Weatherly, you may put your hand down. How are you doing, Ms. Weatherly?
I'm doing well, how are you?
I'm doing fine, thanks for asking. Ms. Weatherly, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you would like to apply, that you would like to have your case reset to hire your own attorney? Now, Ms. Weatherly, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge? Ms. Weatherly, your case will be reset to give you an opportunity to hire your own attorney. And our court coordinator is going to give you your reset. Once she gives you your reset, you'll be free to go and you have a blessed day. Now, Ms. Weatherly, have happy holidays to you. All right, please sit in that third chair.
Okay. I think-
Nadia Lopez. Ms. Lopez, your full name is Nadia Lopez?
Lydia.
Nydia Lopez? Ms. Lopez, would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Lopez, you may put your hand down. How are you doing, Ms. Lopez? I'm doing fine, thanks for asking. Now, Ms. Lopez, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant? And or these your initials on the line that state you'd like to hire your own attorney? Ms. Lopez, before you sign and initial this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Ms. Lopez, your case will be reset to give you an opportunity to hire your own attorney. Our court coordinator is going to give you your reset. Once she gives you your reset, you'll be free to go. You have a blessed day and happy holidays. So you please have a seat in that first chair. The first chair on the wall.
Thank you.
You're welcome. Arthur Gladney.
I can place some stuff on that table.
Okay, Mr. Gladney. Your full name is Arthur DeWitt Gladney. Mr. Gladney, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Gladney, you may put your hand down. How are you doing, Mr. Gladney? That's good, Mr. Gladney. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states you'd like to hire your own attorney?
Yes, sir.
Mr. Gladney, before you sign and initial this document, did you read the document?
Yes.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge? Mr. Gladney, I read your answer. So, Mr. Gladney, your case is going to be reset to give you an opportunity to hire your own attorney. Our court coordinator is going to reset your case. Once she resets your case, you'll be free to go and you have a blessed day. And happy holidays to you. Please have a seat in the chair on the wall. You have
Lopez?
To January.
Give you the name. Both case names, they got two?
Yeah, he's glad we can look at him too.
Oh, I didn't know. Okay. Change that. Like court appointed attorney, which will have to find same. You have the application for the court appointed attorney? Let's see. Jose J. Bernal.
She's gonna be here right now.
Mr. Bernal,
Yes, sir.
your full name is Jose J. Bernal. Mr. Bernal, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Bernal, you may put your hand down. How are you doing, Mr. Bernal?
Not very good, sir.
Okay. Well, we'll hope that you be doing better once you leave here.
Travel.
Okay. Now, Mr. Bernal, I have before me a document that is titled information. Well, actually, that's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled defendant? And are these your initials online that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document? On page 2 of this document, there's a signature above the line that is titled defendant's signature. Is this your signature? Now, Mr. Bernal, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And did you understand everything? Well, is everything in these documents true and correct to the best of your knowledge?
Yes, sir. I have been working over a month.
Okay. Now, Mr. Bernal, I read your answers. Based on your answers, you meet the eligibility requirement. Her name is Elizabeth. So, Mr. Bernal, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. Let's see those bond conditions. Okay, Mr. Bernal, the attorney that will be appointed to represent you in this case is Attorney Christy Cawthon. Attorney Cawthon will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you the information. Just, wait a minute. Will you be able to copy this from me?
Yes.
Yeah.
By the way.
Give you some. Here's some bond conditions. Bailiff has handed you a document that is titled Standard Bond Conditions in County Court Law Number 2. And Mr. Woodall, I'm going to go over these bond conditions with you. It states standard bond conditions in County Court Law Number 2. Following return of a criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, Defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submits to a test for drugs and alcohol and a test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 does not apply, and condition number 4 does not apply, because this is not a DWI case. However, condition number 5 does apply, and states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Bernal, if you violate any one of these conditions, your bond will be forfeited. If your bond is forfeited, a warrant will be issued for your arrest. Do you understand that?
Yes, sir.
Okay. Now, Mr. Bernal, I need you, let me do this. Mr. Worsham, your full name is David Samuel Worsham?
That is correct.
Mr. Worsham, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do,
Mr. Worsham, you may put your hand down. How are you doing, Mr. Worsham?
as well as to be expected.
Okay, that's good. Now, Mr. Worsham, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir, I do.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you would like to apply for a court-appointed attorney?
Yes, sir.
I have another document that's titled that's titled Jefferson County Affidavit of Injury. Do you recognize this document?
Yes, I do.
Now, and is this your signature on this document?
It is.
Now, Mr. Worsham, I had to make some, I guess, corrections on the document because it asks for monthly income. You had put yearly, and so I just divided it by 12. Okay,
Sorry,
the amount that you had. And so I also added up, well, once I did that, I had to change the total income.
Mhm.
So it's gonna reflect that here. Also on the expenses. I guess you had the comma in the wrong place.
I did.
Right, and so I had to basically move it over.
Yeah,
And so what I'm going to do is let you, hold on a minute. I'm gonna let you take a look at the document and see the changes that I made. You can review those.
okay. Okay, yes,
Okay, now is everything on that document true and correct to the best of your
to
knowledge?
the best of my knowledge, yes.
Okay.
Your Honor.
Okay, now, Mr. Worsham, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Giles Cole. Attorney Cole,
C-O-L-E,
yes,
okay.
Attorney Cole will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information, okay? Now, before she gives you that information, I was looking at this probable cause affidavit, or kind of referred to as a police report in this case, and I need to set some bond conditions in this case. Now, let me do this here. State You just been handed a document that is that's titled Standard by Conditions in County Court at Law Number 2. And it states, following return of criminal information in County Court at Law Number 2. Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, Your Honor.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. Court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs, alcohol in the defendant's body. Do you understand that condition?
Yes, Your Honor.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, Your Honor.
Now, condition number 4 does not apply. That only applies in the DWI case. Condition number 5 does apply. It states that the defendant is prohibited from possessing a firearm ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. You understand that condition?
Yes, Your Honor.
Okay. Now, Mr. Worsham, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes, Your Honor.
Okay, now, Mr. Worsham, your case is being reset to give your attorney an opportunity to contact you and you to contact your attorney. And Mr. Worsham, you're gonna have a seat in that first chair on the wall, right there. And then, yes, and Mr. Worsham, you have a blessed day and happy holidays.
Thank you, Your
All
Honor.
right, you are.
Right. This is your first one, this is the phone. And then one of the engineers come in, and this is your attorney information file here. You choose to call me first, or about 4 hours. Okay, thank you. All right, then. Thanks. Have a good one.
All right, you are. Yeah. We have, what is this here? This. The other lady's not here. I was looking for that other lady. What happened to Miss,
She went to, I think she
Oh.
went to the restroom.
oh, she did?
And we still have that.
She probably need to, is she gonna go out next door for, Callista? That's,
Yeah.
Ms. Reyes? Okay. This is cause number 25 CCCR 2360, case of style, State of Texas versus Javinci F. Reyes. Ms. Reyes, would you please raise your right hand? Ms. Reyes, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Reyes, you may put your hand down. How are you doing, Ms. Reyes?
Yeah.
I'm doing fine. Thanks for asking. Ms. Reyes. Ms. Reyes, I have 2 documents before me. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
And you're supposed to put some initials. I see you scratched out some stuff and you circled this line that states you would like to apply for a court-appointed attorney. Is that correct? Also have another document that is titled Jefferson County Affidavit of Interest. You recognize this document? On page 2 of the same document, there is a signature above the line that is titled Defender Signature. Is this your signature?
Yes, sir.
Ms. Reyes, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Mm.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Ms. Reyes, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Jennifer DeLodge. Ms. DeLodge will be given information to contact you, and you will also be given information to contact her. Our court coordinator will give you that information. Once you get the information from our court coordinator, you'll be free to go and you have a blessed day. Please have a seat in that first chair on the wall.
Thank you, Your Honor.
Thank you.
You're welcome.
What you said?
That was Jennifer Boston.
Yes.
Did you go on commercial students? Oh, y'all love me. I could go. They already finished?
Yeah, it needs more than.
It's okay. I'm gonna pick up this. Take the clothes off.
Why was this thing not? Oh, what do I have?
Oh, they're dressed over? That's him up there?
Yes.
Okay, I didn't know. Let's go.
He didn't finish filling this out. You didn't finish page 2.
Oh, I didn't.
Page 2 on the affidavit. The top portion and the middle portion.
Oh, this must be something hard to grab.
We finished with, is that Mr. Kane? Page 2, yeah. We don't have no,
Very well.
plea paperwork. They have a plea? We got one person on this, and I want to Miss Elam, have you talked to one of the prosecutors? There you go, Mr. Elam. What are we doing on Kane?
Oh, yeah.
I need it. Kane is DA?
Yes, sir.
Okay, I need to have him come up. Did you have his paperwork? Where's his paperwork? Kane?
I haven't talked with him yet.
I know. I need to swear him in. All right, thanks. Okay, this is cause number, well, actually, we have cause numbers. 25 CCCR 2358 and cause number 25 CCCR 2359. Both cases are styled State of Texas versus Artest D. Kane. Mr. Kane, is that your full name? Mr. Kane, would you please raise your right hand? Mr. Kane, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Kane, you may put your hand down. Mr. Kane, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? You have to
Yes,
speak
sir.
up. Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to apply, that you like to waive your right to attorney and represent yourself?
Yes.
I also have another document that is titled Waiver of Counsel for purposes of entering guilty plea or proceeding to trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Sir.
Now, Mr. Kane, before you sign and initial these documents, did you read the documents? Did you read the documents before you signed them?
I had them explained to me.
Okay, did you understand? Okay, you said you had them explained to you by whom?
I went over it with them.
Okay. Now, did you understand everything in this document?
Yeah.
Now, you understand that in this document that you said you wanted to waive your right to an attorney and represent yourself. That's what this says. That's what you initialed, right?
Yeah.
Okay, you also understand that you may not speak to the prosecutor unless you first sign a written waiver of your right to be represented by an attorney. And I have before me a document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. You recognize this document?
Yeah.
And is this your signature on the line that's titled defendant?
Yeah.
Now, did you understand everything in this document before you signed it?
Yeah.
Okay. Now, this document, going back to the first document, it states that there are dangers and disadvantages to self-representation. Waiving your right to an attorney representing yourself may result in the worst outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Do you understand that? Now, this document also states that if you waive your right to an attorney, you may change your mind at any time. Do you understand that? Okay. Now, Mr. Kane, just have a seat, and one of the prosecutors is going to come out and talk to you about your case.
Yeah, she just texted me and asked me to get it to him. I told her, she probably been texting my phone, it's in my.
Fine. Okay, I have before me two documents. First document is titled. Oh, okay, you need to make your change on this one too. Because you're changing it from wanting to represent yourself to, you're gonna have to, is there ink pen? Let me give you this here. You're gonna scratch out your initials on the third line, on the fifth line, and put your initials on the third line at the bottom. Okay? You could put that pen right there. All right. Now, Mr. Kane, I have before me two documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
Now, did I swear you in? Okay. And are these your initials on the line that state you'd like to apply for the court-appointed attorney? I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? You have to speak up.
Yes, sir.
On page 2 of this document, where's page 2? Oh, here we go. We don't have a page 3. No, we don't have a page 3 on this document.
I didn't get that to it.
Oh, I got 2, but I don't have 3. It's good. Now, on page 2 of this document, there's a signature. Wait up. Okay. Miss Mosby,
Sir?
hand this back to him. He put his initials, he's supposed to put his signature on page right here. Okay. Was that the one for Marvel?
Monroe.
Ms. Program.
Okay, let's see. Okay, now, Mr. Kane, is this your signature on page 2?
Yes, sir.
Now, Mr. Kane, before you sign any initial the documents that I just showed you, did you read the documents? And did you have someone to help you to understand, and you understand everything in these documents? And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay. Mr. Kane? I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney and the attorney that will be appointed to represent you. In this case, is Attorney David Grove. Attorney Grove will be given information to contact you. Okay, Mr. Grove will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Now, Ms. Mosby, could you give him a form to CICE? She's gonna give you a form. You weren't here. I think you was listening over the Zoom. And I mentioned that we have a partnership with the Golden Triangle Empowerment Center. It's a partnership with Lamar University. And Lamar University has a program that is called CICE, stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you get trained in any one of those areas, they'll help you to get a job. If you do not have a high school diploma or a GED, they can help you. They have a GED program, okay? So, Mr. Kane, let me do this here. You're going to get your reset. Once you get your reset, you need to You'll be free to go. Make sure you keep your pants up and your head up, okay? You have a blessed day and happy holidays. Okay. David Grove.
Over 2 years back. Oh, yeah. I was crying, you was crying. I said, I got a uniform, Friday uniform.
Okay, this gentleman, what we doing, Miss,
She's
Yeah.
a hired attorney.
Oh.
She need to reset to hire an attorney, though.
okay, Miss Elam? Would you please come forward? Hey, Miss Elam, why don't you come up here? You have some gum in your mouth? You just swallowed it? Okay,
Sorry.
yeah.
How you doing?
Hmm?
How you doing?
I'm doing fine. And how are you doing?
Fine.
That's good. Saving the best for last. Okay. Now, Miss Elam, well, first of all, would you please raise your right hand? Swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God. Now, Miss Elam, you may put your hand down. Now, Miss Elam, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. And do you recognize this document? And is this your signature on the line that's titled defendant?
Yes, you are.
And are these your, okay, yeah,
Yes,
your initials is on the line that states you'd like to hire your own attorney. You scratched out at one time you wanted to waive your right, but now you want to hire. Is that correct?
Yes, sir.
Okay. Who is this here? This is Kane. Now, Miss Elam, before you signed and initialed this document, did you read the document? Did you read the document
Mhm.
that you signed and initialed? And did you understand everything in this document? And is everything in this document true and correct to the best of your knowledge? Okay, Ms. Elam, I read your answers. Based on your answers, you meet the eligibility requirements. Based on your answers, your case will be reset to give you time to hire your attorney.
Yes, sir.
Now, before the court coordinator give you your reset, I need to give you some bond conditions. Now, Miss Redmond, did you make a copy of these bond conditions?
If y'all gonna make.
Okay.
you're gonna do it here.
She gonna do it here, yeah. It'll be a lot faster.
Well, I can
We're gonna do a she got a copy machine right here. Yeah. So we moving up. We have a copy machine in the court now. They had to go to the back.
Used to work my little short legs.
What we gonna do with him? Oh, okay. Okay, now, Miss Elam, there's you've just been handed a document that is titled Standard Bond Conditions. I'm going to go over these bond conditions with you. And Ms. Elam,
I'm listening.
all right. It states, following the return of criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional condition. Number 1, defendant shall commit no offense against this state, any other state, or against the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order arrest of any defendant who, A, refuses to submit to test for drugs and alcohol when directed to do so, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. You understand that condition? And condition number 2, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
That's Nakia Patterson, Judge.
Okay, that's the victim. Okay, and the defendant, and condition number 4 does not apply because that only applies in a DWI case, and your case is not a DWI case. Do you understand that? Now, condition number 5, defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Okay, now, Ms. Elam, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant can be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Okay, now, Ms. Elam, your case is going to be reset to give you time to hire your own attorney. Okay? Yes.
Okay, say, I run into a victim from
Go the other way.
that victim come towards me.
Go the other way.
Well,
Okay.
I gotta protect myself.
Well, go the other way. All right? You can't have no contact. I mean, just make sure you abide by these conditions, because if you don't abide by these conditions, your bond can be revoked. And if your bond is revoked, warrant will be issued for arrest. You'll be arrested and placed in the Jefferson County Jail.
Yes, sir.
All right. All right. Now, Ms. Elam, let me do this here.
Just one out for the court, since she's represented herself previously, Judge, I had made available redacted versions of the offense reports
Okay.
for her, Judge.
All right. All right. Now, Ms. Elam, your case is going to be reset. You have a blessed day and happy holidays to you. Here you go. Oh, Miss Mosby, she need a CICE.
Oh.
She's gonna give you the brochure. All right.